Good evening and welcome to the Womxn Show. I'm Jameelah Omar. Tonight we're going to be speaking about a difficult topic, child sexual abuse and incest. Now before we get into these conversations, I want to caution you, the viewers at home, that some of the narrative will contain graphic descriptions of sexual abuse, and if you need to get help, you can see there's a number on screen for Rape Crisis, which will be shown at the end of the show as well. Now, we all know that child sexual abuse happens. We protest and march about it every year, but in reality, nobody really wants to think about the fact that adults fondle, touch, kiss, and rape very young children. This week, in October 2020, a young woman uploaded a video to YouTube alleging that she was sexually abused by her grandfather from the age of 5. She also alleged that her grandfather and his twin brother, both now in their 80s, sexually abused a number of women over decades. We're going to have a listen to a short piece from that clip and hear what she had to say.
I'm a sexual abuse survivor, and 3 years ago, I shared a post on Facebook, a Me Too post, and it was the first time that I publicly shared that I was sexually abused as a child. I didn't mention any names or give any details. For people who know me, and even for people who don't, but who are part of the community that I'm from in Cape Town, what I'm going to say is probably going to come as a shock to many of you. I was sexually abused by my paternal grandfather, Hassan Emran, and his twin brother, Hussein Emran, was also a child molester. They have abused girls for decades. There are women who are now in their 50s, in their 40s, in their 30s, in their 20s. There are girls who are teenagers who have been abused. Abuse occurred last year in 2019. And since then, over the past year, I have spoken to many others who have been abused by these men. I was 5 when the abuse started, and at the time, I thought that I was the only one being abused by Hassan, and someone close to me, close in age as well, was being abused by Hussein. I don't want to put it out so publicly what happened to me and many others, but the abuse didn't stop, and these men are or have never been held accountable. They've abused girls in the family, in their wives' families. And I know that it's very easy for people not to believe it because of who they are and how well they're respected, the things that they've done for the community.
After the break, we're going to be speaking to a number of experts about child sexual abuse, incest, and the legalities around late reporting of sexual abuse. But before that, we're going to take a short break. We'll be back with more after this. Welcome back. You're still watching The Womxn Show. I'm Jameelah Omar, and tonight we're speaking about child sexual abuse and incest. And joining us in studio is a registered social worker in the forensic field, Professor Vollie Spies, who is also an emeritus professor in the Department of Social Work and Criminology at the University of Pretoria. Welcome, Professor, and thank you for joining us.
Thank you, Nina, and I would like to say hello to all the viewers also.
Thank you. So, Professor, we are looking into incest and child sexual abuse. Before we go into the conversation, could you just give us a legal definition of incest and what that is?
Yeah. I need to start at the point where I would like to say this is one of the forms of child sexual abuse that is the most difficult one to define. And even with the legal definition, it's not saying what we would like to hear in the community, what it's all about. But let me try to say the following. The incest is an unlawful but also intentional contact between people that are blood related to each other, but that the sexual intercourse actually have to take place to refer to it as incest itself. But unfortunately, this definition cut out very often family systems, remarried family systems where there's step relations, etc. But they do function actually as a family system. And the same scenarios actually occur there that can develop into incest as families of origin. So it's quite difficult, to define it. And the other thing is that many researchers actually refer to incest as a form or a way of a family system to try to maintain themselves. In other words, that it's a way to address problems and issues that divide the family members in a family system, for example. But we know that it doesn't work this way. It's not helping the family to find solutions. It actually makes it worse.
Thank you, Professor. I'm going to ask, some of your research into incest stated that the impact of incest is found to be more severe, the impact of child sexual abuse is found to be more severe if perpetrated by a known person. Could you tell us a bit more about that?
Yes. I think the very first reason for that, it's blood related. In other words, these people do know each other, and most of the time there will be a trustful relationship. If it's between an adult and a child, which incest refer most of the time to, it means that there was already a trustful relationship, or at least a adult person who will take the responsibility for that child, look after that child, and also create a safe environment on an emotional level, but also on a physical level. And the moment these things start happening, that emotional safety and physical safety actually became very risky for the child. So that child, even if they don't know what incest is all about in terms of by defining it, they just know, they realize that they experience discomfort, and also they lose their positions in the family system. A child become all of a sudden an adult person. There's role confusion that's taking place. And most of the time, say for instance, it's between a father and a child, that children actually lose the other parent in a way that maybe I stood in for that parent and I need to be loyal to that parent. So, but the loss of childhood is actually the more severe thing that's happened with these children.
Yes. Thank you, Professor. I'm going to ask, in cases of incest where the perpetrator lives in the same home as the victim, we see, or we often hear, as was the case with the YouTube video this week, that the abuse carried on for quite a long time. And people find this hard to understand. Even, responses often to the video are, as she got older, why didn't she say anything? Can you explain some of the dynamics around long-term abuse and why it's difficult for victims to come forward and disclose?
Okay. We must realize that incest is, the moment it's been disclosed, it means actually that this process comes from very far already. It's not that incest starts on the day with intercourse. And that is one of the other problems with the definition. Because if you think about the legal definition of incest, it means intercourse. according to me, there's other forms of incest without intercourse that is also damaging the child's life and the whole family system. So, for example, just touching a child's genitals or expose a child, to adult sexual genitals is also a form of incest because it's blood-related persons. And the same losses actually start, taking place in that family. Now, the reason why it is not on time, maybe in inverted commas, being disclosed, means that it becomes a secret in that family system. Now, if you look at the research on incest, the fact that it's a secrecy, taking place in secrecy, because the adult person knows it's unlawful to do so, there's many other reasons why they keep a secret. First, sexual discussions about sexual development in that families will never ever take place, and if it takes place in a very negative way. Very often the children, depending on their age, they haven't got the vocabulary actually to share what's happening with them. Most of the times, these children, and not in all the situations, but in many, these children are actually already at risk even before the incestuous patterns start to develop. Let me give you an example. If I have a mother figure that's been sexually abused herself as a child, being referred to as an adult survivor of child sexual abuse, it damages so much your parenting skills because children remind you about your own abuse. So you try to create distance between you and your child, not because you want to, but because you're so scared you see yourself in there and it opens up your pain that you try to bury it so deep that you not even think about it. So that creates a vulnerability with that child that became the risk in a possible incest or even outside the family system by looking for warmth, looking for acceptance, and if the sexual activities start in terms, and they define it as warmth and acceptance, then that become a scenario that the child's emotional feelings or needs become sexualized. And that is one of the reasons why these children cannot open it up so easily, because that's all they know. But very often the children knows about the legal systems, especially your teenage children, and they see it on TV, they see the news, etc., and they're extremely scared of the legal system. They also feel ashamed, maybe it's my fault. Maybe I did something wrong, and said something wrong. So I started it all from the beginning. Or they feel I liked it because I never screamed, I never ran away, I never shared it. And it become more and more difficult because I think I am the culprit. Now, looking at that, if it's a father or a person that maintain the family system through a salary or a work situation, in other words, the breadwinner, if I am saying something, I know the legal system say that person is going to jail, of course. So what is going to happen to us? And immediately moving into an adult person role and take responsibility for the whole family system to maintain the system. And of course, we know that responsibility is just too heavy actually for that child. But this is some of the reasons why it becomes so difficult. And of course, manipulation, and also the fact that I've been blackmailed, if I'm doing this, then this is going to happen to me. But I also know children that use the favors that actually come with the incest. So I received 1,000 Rand pocket money in a month and not 200 Rand like the others. So, it helps. And they start weighing up the pros and the cons. And this is not consciously, more subconsciously, because they are emotional needed children already.
Yes, thank you, Professor. You're also making me think about the issue of grooming. So when you're speaking about sort of pocket money, there have been scenarios or where we've listened to, I guess, testimony from perpetrators. You'll often find that the rewards will start first before, they'll get pocket money for 6 months.
Yeah.
And then 6 months later, it will, you know, either to maintain the pocket money or I want to even say pay back.
Yes, you see, the children they haven't got the capacity actually to distinct between right and wrong, especially on a very young age. And they get used to the rewards that they get because they feel that they are okay, they accept it and they've been wanted in a way. But also the fact that you know, we call that grooming in some way. So the adult person knows what he or she is doing, and they will groom this child and actually move this child into a position that it becomes totally impossible for that child to open his or her mouth. And this is the sadness, the pain, the losses that children experience over a long period of time. And that's the reason why I always say, the moment it becomes into the open that a child has been sexually abused through a form like incest, we need to look at not only the child but the rest of the family. Because I can say to you without doubt that incest in a family system, not touching only the child that is at risk or being part of the incestuous relationship or the adult, the parent in that for example, but the whole family system is then at risk. So we cannot concentrate on the perpetrator and the victim only, but the whole family system. And I personally think that we in South Africa are not geared actually to do what I've just said, you know, by looking at the family system as a whole.
Yes. Professor, I want to ask about, you spoke about, you know, elements of feeling guilty and the victim blaming themselves. And your research also mentions that one element of that is that sometimes the children's bodies would react, so bodies physically, even if they don't want the abuse, would react positively to the touching or so forth. And that also results in trauma and confusion and misunderstanding and then blame. Could you speak a little bit to that?
Yes. I've never met a child in the 40 years that I'm working in this field that not experienced a form of guilt after the disclosure of specifically incest. And one of the things that especially the older children, and I'm referring to the children above 6 years old, you know, they would say, but maybe it is my fault because I responded. Physically, I responded. And it's very difficult for children to accept that they are not only human beings, they are also sexual human beings. And this is a reality. Now, very often these children has not been guided in the early childhood between 2 and 6 or 7 years old, you know, by helping them with sexual differentiation. In other words, to realize that you know, I also have feelings. When I touch my genitals, there's a feeling, and this is okay. This is a good experience, but it's mine. It's private. And I have the right to protect that. So if that didn't happen, and later on with all the interviews, with all the consultations, with all the professionals that come down on the shoulders of these children, they start feeling, well, okay, so many people are talking to me, so I must be the culprit. I should have actually stopped. I should have not respond and have this good feeling while, you know, the incest actually took place. And that is a very sad experience of children, and only therapeutic intervention can actually turn it around. Another thing is that when a person actually goes to prison, which I have no problem with, you know, if a perpetrator has been found guilty or admit, you know, even before the case started, you know, I did something wrong to a child. These children at a stage always feel that they are responsible for that family member to go. And one of the reasons for that is that we're not helping, not creating support systems for these children. And we as professionals are not the only resource systems. That's why we have to work with the family system, with the external family members, you know, to come into play with resources and supporting this child and help this child to make another mind shift, you know, by saying, even if I was a child, even if I responded, I never did something wrong. You can't, being a child, doing something wrong in that regard. And you deserve, actually, to feel that even if I did something wrong, there was an adult involved that should guide me in the right way. And that helped children to get in touch with their own feelings, with their own person, being a child, the rights of being a child, to be looked after, be protected, etc., because they can't do it on their own. So it's long-term therapy, but unfortunately, most of our children is not receiving that. And that, for me, is the pain in South Africa.
Yeah. Professor, we don't have much time left, but before we go, I just wanted to ask you, you mentioned, family systems, and I know when we spoke earlier, you were talking about risk factors, and I was just wondering from your experience, whether there's any, I don't know, I guess advice that you could give to families about child rights, about safety.
Yeah. There's certain factors that one can look out, and professionals also need to look out for risk factors in families. I've never met an incest family or incestuous family where the marital relationship is a healthy relationship. And this is where the problem very often starts, the distance between marital relationship. But together with that very often one or both of the parents in that family systems are adult survivors of child sexual abuse. It's not always the case, but the incidence is quite high. So they are both immature. When children start taking over parents' roles and the intergenerational boundaries, in other words, the boundaries between the generations the last 3 generations, grandparents, parents, and children, when that intergenerational boundaries become very diffuse, in other words, very unclear, and everybody is doing everybody's job, and this is okay, taking over mom's role, taking over dad's role, and act as an adult. Not that I'm doing a favor for my parents, so that this is not the problem. When these things start happening, this is an indication, that there's disrespect in the family system, personal boundaries is not being looking after, children feel lost because the parents not taking responsibility for them, but rather referred it to other children, elderly children in the house. In other words, it become a dysfunctional family system, and very, very important, become very isolated, from the community. They will go to church. That would be the very often the only thing that they will attend, and the schools. But the children is not attending school activities after school hours. They're not going out with their peers, etc. But in other words, it's forbidden. It become an isolated family system, and the family have to learn to cope inside that parameters. And this is where incest often become a way to survive in that family system. But I have to say, it's not one or two aspects. It's the culmination of many others coming together, and this start developing. And it developed over years. But it can also be transferred from an elder child to a younger child, especially when the elder child move out of the system and someone actually have to take it over.
Thank you so much, Professor. Thank you so much for joining us and all of those insights.
That's a pleasure.
That was Professor Vollie Spies, who is a registered social worker in the forensic field and an emeritus professor in the Department of Social Work and Criminology at the University of Pretoria. We are going to take a short break, but we shall be back with more after this. Welcome back. You're still watching The Womxn Show. I'm Lenina Rasool, and tonight we're speaking about child sexual abuse and incest. Now, there has been an increase in disclosures by women who have come forward many years after the abuse has stopped. And recently, South Africa abolished our statute of limitations, which means that you can charge a perpetrator regardless of how much time has gone past after the abuse. Joining us now is Jameelah Omar, who is a senior lecturer in public law at the University of Cape Town, and she also specializes in sexual harassment and abuse. She will speak to us about late disclosures of historical abuse. Jameelah, thank you for joining us.
Oh, you're welcome.
So Jameelah, we're speaking about child sexual abuse. There's a video that surfaced on YouTube of a young woman accusing her grandfather of historical sexual abuse. She hasn't laid any charges. So I'm going to start with the fact that there's been some high-profile cases in South Africa of historical sexual abuse, and most notably it was the Frankel 8, which resulted in South Africa abolishing our statute of limitations. So I just wanted to ask, to start with, like, what is a statute of limitations? How did it apply to sexual assault before, and what does it mean now that it's abolished?
So so in South Africa, we more commonly refer to it as prescription rather than statute of limitations, but it's basically the same thing. And what it is normally lives in a statute or in the common law, and it stipulates a period of time within which someone can lay a criminal charge at a police station and expect that it can be prosecuted. So nothing stops someone from walking into a police station at any stage and laying a complaint. But if it's outside of the period within which it can be prosecuted, it means the case can't go anywhere in terms of a court process. So that's what it means. And previously, before the case that you're referring to, which is the Womxn and others versus Estate Frankel, before that case got to the Constitutional Court and an order was handed down, the period of prescription for sexual offenses, except for rape and compelled rape, was 20 years. So you had 20 years within which to lay a complaint at the police and for the prosecution to take that forward. Since the order in that judgment, the period of prescription for sexual offenses has been removed. So there is now no time limit within which a sexual offense case can be taken to court.
Okay. It's almost like an expiry date. I mean, if you wanted to.
Yeah, yes, exactly. And I think, part of the reason is for the integrity of the evidence. So if there was forensic evidence, there's only a certain amount of time that evidence could still be credible. And also in terms of the primary evidence that we use in Anglo-American systems, which is oral testimony, there's only a certain amount of time within which you can trust that someone's memory and the way in which they recall and can explain things can be credible, or at least that's the assumption that our legal system makes, that, after a certain amount of time, you start forgetting the details. So there are good reasons for prescription as well. It's not entirely without sense behind it. But what the Womxn case very, very clearly articulated was that there was an arbitrary distinction made between rape and other types of sexual offenses. And actually there was no, it was an unconstitutional distinction being made without any real rationale. And on that basis, that expiration period, as you describe it, was removed.
I see. Okay, which is interesting that you mentioned that in terms of evidence, because my next question sort of relates to that. So, South Africa, and I think across the world, we have very low conviction rates for rape anyway. And so given that, what does this mean for older sexual assault cases, especially with regard to that law of evidence and the burden of proof?
So I think, yes, I suppose the one thing I would caveat is that this is an issue of immense debate amongst experts about whether sexual offenses have such a low conviction rate, or whether in light of resources, both the police, the prosecution, the courts, whether the number of cases that are taken to court and the percentage of that are successfully prosecuted is not just, the expected number. It's not necessarily low. It's just the reasonable number of cases that you can expect to reach a successful prosecution. But that is a matter of debate. And currently, on average, only about 10% of reported cases ever get prosecuted. Out of that, somewhere between 50% and 70% of cases are successfully prosecuted. So that's with a guilty verdict. So, the number of successful prosecutions out of those taken to court are not actually that low. It's 50 to 70%, which is quite high. Because of the fact that the state has such a high burden of proof to meet. If 70% of cases are reaching a guilty verdict, that's actually a very high statistic. The low statistic is the number of cases that are even getting to court in the first place. So both statistics are important to keep in mind. And actually, it isn't the conviction rate that is particularly problematic. It's the number of cases that are even going any further than the police stage. So that being said, in relation to the second part of your question, what does this mean for historic cases or for incidents that occurred a very long time ago? The fact that we've taken away prescription, does that help us at all? Are these cases ever going to get to court in the first place? So I think, I can't really answer that because, first of all, I don't work for the NPA. So what I can say is that there will now be no absolute bar on those cases getting to court. It means that it's now a possibility when before it was not a possibility at all. But a prosecutor will still have to take into account the same issues like, is there a reasonable chance, a reasonable prospect of success? Is there sufficient evidence to meet the burden of proof? Is the victim in the case willing to cooperate? So all of those same issues that a prosecutor will have to consider in any other case will have to be considered here. And with, as I said earlier, it's unlikely there would be any forensic evidence 20 years. It's possible, it's not beyond the realm of possibility, but it's unlikely. Or even if it did exist, if it's never been tested in a forensic lab, it would definitely be open to opposition to admit that, just because you can't be sure that there's been the chain of custody, or that evidence hasn't been tampered with or just disintegrated over the years. Unlikely you have any forensic evidence. And then the other evidence that you'd rely on is witness testimony, both from the complainant and then any other witnesses. And so this still remains a feasible option if you've got witnesses that can recall and can put forward a case in court very well. It's possible that the prosecutor could still have a very strong case. So I wouldn't say that it's totally out of the question based on time, that very old cases can't go to court. And in fact, the Levenstein case was exactly that. There was sufficient witnesses with the sufficient recall of the issues to go to court.
I see. Thank you so much. That's very helpful. I also want to ask, so in this case, charges haven't actually been laid. What has happened is that a young woman has, told her story and made these allegations on Facebook, naming the alleged perpetrators. And so one has to wonder, what does this mean legally? Are there grounds for defamation? Are people allowed to do this?
So, I mean, again, this is another area of debate. So first part, are people allowed to do this, I think, is the first thing. So it's not the appropriate way to lay a police complaint, obviously. I would say in this case, it's not clear that the victim has any intention of laying a police complaint at all. So, you know, the area of debate would be that some people would say, and I mean, this is, you know, both colloquially and amongst experts, that you either need to lay a police complaint or you effectively find other ways of healing outside of the criminal justice system. There are other people who would say, well, the rule against, you know, publicly disclosing the name of an alleged perpetrator only applies if you are planning to go to court. If you're not, then it's not before court. And the same rules, like in the Criminal Procedure Act, there's a particular provision, section 153, if I'm not mistaken, that prohibits the disclosure of the name of both the victim and the perpetrator in a sexual offense that is before the court, but one in which the accused person has not yet pleaded. You can't publicize the name of the alleged perpetrator in that situation. And so this is definitely a case where the accused hasn't pleaded, but it's also a case where no charges have been brought. So it's a somewhat gray area. And I think, you know, should the complainant decide to lay a formal police complaint, there may be issues about the fairness of the trial, etc., with having put public information into the public domain outside of the criminal process. However, it's not clear that that's going to happen.
Yeah.
The second question about defamation, yes, I think this does open up complainants to defamation suits. However, truth is a defense to defamation. So if the person making the statement in the public domain can show that the allegations are based on truth, then that will be an absolute defense to having supposedly defamed the reputation of the alleged perpetrator. And I think one thing to keep in mind, the burden of proof in a criminal case that the state has to meet is beyond a reasonable doubt. That's a very high threshold. A defamation case, which is a civil suit, the matter is decided on a balance of probabilities. Mm-hmm. So the person making the statement doesn't have to show beyond reasonable doubt that it's true, just that on a balance of probabilities, it is true. Something very important to keep in mind when these threats of defamation are made, in my view.
I wanted to ask, Jameelah, a development in the Tasney van Wyk case was that the perpetrator was related to her and incest was added as an additional charge. And so this happens in cases of interfamily abuse, as is alleged by the young woman in the YouTube video. And I just wanted a bit more context about that. So is it an extra charge? Is it also important?
So that seems a little bit unclear in terms of the Criminal Law, Sexual Offences and Related Matters Act. I mean, technically, any sexual penetration without consent is rape, and it doesn't really matter whether there is a relationship of any kind, whether familial or any other, between the victim and the perpetrator. So it's clearly rape. Why incest might be added as an offense is, I think, first of all, because under the common law, incest was incest was sometimes used when there was incestuous rape, which is the phrase that has been used in some case law. But in addition, incest might be added to the charge sheet if it seems possible that the accused person might say that there was consent.
I see.
The relationship, because Section 12(1) of SORMA, Section 12, subsection 1 of the Sexual Offences Act, stipulates that incest is prohibited regardless of whether there is consent or not. So it doesn't matter whether the two parties consented. If there's a direct line or even an indirect one through adoption or through some other type of relationship that is specifically prohibited, then it doesn't matter. Of course, in many of these cases of incest, it is a child victim, so consent is completely irrelevant in any event. So it isn't always clear why incest is added to the charge. I mean, as Supreme Court of Appeal court case in 2002, where this phrase incestuous rape is used, and it's used in the context of saying that this type of rape, which occurs in the family context, is extremely damaging to the victim and their perception of trust and security, etc., and then also the knock-on effects on the rest of the family. But those comments are made, in my view, as contextualizing statements about the seriousness of the offense, rather than to describe the offense itself, if you understand what I mean. So I think it can be added, but I also think it doesn't always have to be.
Yes. And then, Jameelah, just to sort of end off, so cases like the YouTube video, as we have seen with #MeToo movements before, and these waves that are happening right now around sexual assault, they always spark some more disclosures, whether it's online or also public, or, and so if people decide that they want to go and lay a charge about historical sexual abuse that happened to them that they've never reported before, what do they do and how do they do this?
Okay, so they can report, I mean, at any stage. Nothing stops them from that. And they can do so at a police station. They can even do so at any police station, because that's what the guidelines say. A complaint can be made at any police station. So it doesn't have to be the one that has jurisdiction over the area in which the offense occurred. It can be any police station. However, in my experience and in many others, victims are sometimes told, no, you can't report here, you have to go to the place where it happened. That shouldn't be the case, but to make it easier for yourself, if possible, go to the police station where closest to where the offense occurred, just to avoid being given the runaround and having that additional fight, which I think is really. I think the process of reporting and going to court is hard enough, and so if possible, just go to the one closest.
And
but technically,
just to ensure that the docket is where it's supposed to be, because if you want
exactly. So I mean,
transferred.
So in sexual offenses, the reason why you can go to any police station is because it's not actually the station that will take the formal report. We've got a special unit called the Family Violence, Child Protection and Sexual Offenses Unit, and they are in effect a kind of roving unit. So if you went to a police station and you said you wanted to report a sexual offense, or for that matter, domestic violence or a child abuse case of any kind, even if it wasn't sexual abuse, the station should call the FCS unit, and they will send someone to the police station to work with the victim and take the victim's statement. So it shouldn't be the station itself. And that's because we've tried to supposedly specialize in this area, because you need a special type of sensitivity training, etc. And to exactly avoid the situation where a victim is sent from this station to that station. No, first go to the hospital. No, first do that. No, do this. So this is supposed to make it more expedient. So it is also possible to call the FCS unit directly. And they've got premises in a number of different cities, definitely in Cape Town. And you can call them and then go straight to them instead of going through a police station. Or you can arrange to meet them somewhere, etc. I mean, if it's helpful, I can provide the number for contacting that FCS unit in Cape Town. It's 021-467-8390. So if anyone does want to make contact with the FCS unit, that might be the best way to find out how to go about doing it without getting sent from place to place.
Yes.
Another option is also for a complainant to approach one of the Tutuzela care centers, the TCC. These are, for those who've never come across this before, they're supposed to be one-stop shop centers where you can, where the police will be called to make it, and you'll make the statement right there. There are safe rooms, there are doctors on standby to do rape kits and take other testimony. There are lawyers if necessary. So it's a much more friendly environment aimed at making sure that nothing falls through the cracks in a sexual offense. So that's another option.
Okay, well, thank you. Thank you so much, Jameelah. We're out of time, but we really appreciate the narrative and the commentary, and especially the useful information.
You're welcome. Thank you for having me.
Thank you.
That was Jameelah Omar, who is a senior lecturer in public law at the University of Cape Town, who also specializes in sexual harassment and abuse. We are going to take a short break, but we'll be back with more after this. Welcome back. You're still watching The Womxn Show, and we're speaking about childhood sexual abuse. Now, we've heard from a number of experts around this and the legalities around child abuse and reporting it. Now we're going to speak to a young woman from the Cape Town community who is trying to shine the light on childhood sexual abuse and also challenge stereotypes that are often applied to young girls around sex. Shanice Appels ran a campaign on Facebook which really embodied the message that little girls are not ougat. We'll speak to Shanice a little bit about her campaign and what she's trying to say with it.
When I started the campaign, she's not ougat, not only to bring awareness to the sexual assault of brown girls in our communities, but also to have us unpack why, as colored women and as a community, we are so against our victims coming out. In our areas, they use the term ougat to victim shame people that come out to say, like, look, somebody touched me without my consent. Like, there was this one girl, she was raped by a mom's boyfriend, and the first thing the mom told her was like, "Asfanja, your ougat." It was never like the guy was the issue. It was the fact that maybe you did something that sparked the sexual desire in that man. You're only 3 years old. How do you spark a sexual desire in a man? Just seeing how so many women, some were like 50, 60 years old, coming to me saying thank you. And that was when I saw that, like, the term ougat is such a not only horrible, but it still holds so much power, and it's such a trigger. So the term ougat, it still exists up to this day. If you wear a short skirt, they'll be like, just ougat. If you were raped, just ougat, like, what did you do? A lot of colored mothers use that term to sweep acts of sexual assault under the mat. The change that I've always wanted to see was for colored women to actually heal, man, because a lot of the times our own mothers have maybe been assaulted or have been violated, and their mothers didn't know how to handle it because maybe their mother themselves was also raped. So that cycle that we have been constantly on of not healing, because healing from trauma is a privilege. I want us to be able to go to our mothers and be like, look, I was touched, I was raped. Can you help me? I don't want us colored girls to constantly live in fear because our mothers didn't heal from their trauma. We shouldn't teach our kids the same things that we were taught. We should break those generational curses. Just like I said, I want us to destroy the terms of Jintu and ougat and Moenie uit die huis uit praat, because we are teaching our kids now.
That's all we have for this evening, and remember, if you are dealing with any issues around sexual assault or you have been raped, need to disclose, need support, you can contact Rape Crisis on 021 447 9762 or see their website www.rapecrisis.org.za. I'm Lenina Rasool. Good night.